Your company has a 25 crore claim against another business. Your contract is strong, your invoices are acknowledged, the email contains admissions, and eventually you win. But when you finally try to enforce that judgment or award, there is nothing meaningful left to recover. The property has moved, the bank accounts are empty, the valuable receivables has disappeared. अब बताइए केस जीत कर भी अगर पैसा रिकवर नहीं हुआ तो कमर्शियल विक्ट्री कहाँ हुई? That is why in a serious commercial dispute, the first question should not merely be can I win? It should be what will still be available when I win? Hi, I'm Advocate Ashish Rishi from Northwest Legal Consultants, India. And today I am going to discuss an ordinary recovery notice. I want to discuss something far more important for promoters, CFOs, general counsels, and businesses dealing with substantial commercial disputes. Asset preservation before your final judgment or arbitration award. Because sophisticated litigation is not merely about obtaining an order. It is about making that order economically meaningful. Let us first remove one dangerous misconception. If somebody owes you 5 crore, 10 crore or 50 crore, you cannot simply walk into the court and say freeze all their assets. That is not how Indian law operates. A strong monetary claim does not automatically create a right to attachment. The court will examine the application, the statutory test, the nature of relief sought, and the evidence placed before it and the actual risk requiring protection. यही फर्क है aggressive litigation और intelligence litigation में. Aggressive litigation says sue immediately. Intelligence litigation says before we sue, what exactly are we trying to preserve? Now assume your contract contains an arbitration agreement. One of the first provisions sophisticated counsel will examine in Section 9 of the Arbitration and Conciliation Act 1996 of India. Section 9 enables a court in appropriate circumstances to grant interim measures connected with arbitration. These may include preservation of property, securing the amount of dispute, interim injunctions, appointment of a receiver, or other protective measures recognized by the statute. And timing is very critical in this. Section 9 may operate before arbitration starts, during the proceeding, and even after the award but before its enforcement. Now, an important procedural point. If the court grants interim protection before arbitration proceedings have commenced, the arbitration must ordinarily be commenced within 90 days of that order, unless the court permits further time. And once the arbitral tribunal has already been constituted, the court ordinarily should not entertain a Section 9 application unless it finds that the remedy under Section 17 would not be efficacious. So this is not file Section 9 everywhere. This is about choosing the right remedy at the right stage before commercial position deteriorates. And there is a very important 2026 Supreme Court development which corporate lawyers should know. In Home Care Retail Marts Private Limited versus Harsh and Sanghvi, reported as 2026 INSC 415, the Supreme Court considered an interesting question. Can even a party which has lost the arbitration approach the court under Section 9 at the post-award stage? The Supreme Court held that being unsuccessful in arbitration does not, by itself, exclude a party from invoking Section 9 after the award. And this is important. The court emphasized greater caution and recognized that the threshold of an unsuccessful party seeking such protection would be higher. Why is this judgment commercially significant? Because it reinforces an important principle. Interim protection is not merely a procedural sideshow to arbitration. In the right case, it can determine whether the dispute remains commercially worth fighting. Once arbitral proceedings are underway, Section 17 becomes extremely important. The arbitral tribunal itself can grant interim protection in respect of matters including preservation of property, securing the amount in dispute, and interim injunctions. And a Section 17 order is not merely a polite suggestion from the arbitrator. Subject to appeal framework under Section 37, such an order is treated as an order of the court and is enforceable under the Code of Civil Procedure accordingly. So when we analyze a serious arbitration, four questions matter. What stage are we at? What forum should we approach? What asset requires protection? And most importantly, what evidence proves the risk? Now suppose there is no application arbitration agreement and the dispute proceeds as a civil or commercial suit. This is where you will often hear Order 38 Rule 5 लगा दो, property attach करवा देते हैं. But that statement by itself is dangerously incomplete. The Order 37 Rule 5 of Code of Civil Procedure deals with attachment before judgment, but it is not intended to convert every money claim into asset freeze. The provision completes a situation where the court is satisfied that the defendant, with the intention of obstructing or delaying the execution of a decree that may ultimately be passed, is about to dispose of the whole or part of the property or remove property from the territorial limits of the court's jurisdiction. The court may then, depending upon the circumstances, call the security, and rule also provides for conditional attachment. So compare these two statements. Statement number 1. The defendant owes us 10 crores. Statement number 2. The defendant owes us 10 crores. These are the identified assets. This is the documentary evidence, and these specific transactions demonstrates a risk to future execution. These are not the same cases. Commercial court decides on material, not on outrage. This brings me to something that businesses routinely underestimate: the pre-litigation asset dossier. Before deciding how aggressively to litigate, understand what actually exists. Depending upon the case and what can lawfully be ascertained, what immovable assets are identifiable, what charges or encumbrances already exist, are these significant receivables, are these valuable shares or securities, are major contractual payments expected, what are public availability corporate records indicate, what pending litigation or insolvency exposure exists, are assets already pledged, who actually owns the commercial valuable property. कई बार क्लाइंट पूरा केस लाइबिलिटी पर बनाता है, लेकिन रिकवरी आर्किटेक्चर पर ऑलमोस्ट जीरो वर्क होता है. दैट इज बैकवर्ड्स. If commercial objective is recovery, enforcement cannot be an afterthought. You should be thinking about the end of the dispute at the beginning of the dispute. Now look for genuine warning signals. Did important assets being moving immediately after payment was demanded? Has the related entity suddenly entered crucial transactions? Is a key property being sold? Has there been a material restructuring? Do representations made during negotiations contradict documented financial conduct? Are funds or contracts moving in a manner relevant to the relief being sought? One fact may prove nothing, but a well-supported sequence of facts can tell a very different story. So don't merely tell a court the opposite party is dishonest. Show the transaction, show the timeline, show the assets, show the inconsistency, show the risk. Documents pursued, drama doesn't. This becomes even more important where an overseas company is dealing with an Indian counterparty. Suppose your client is headquartered in London, Singapore, Dubai, or New York, and a substantial dispute arises in India. Do not examine only how strong is our claim. Also examine where are the assets. What is the arbitration clause? What is the seat? What interim remedies are potentially available? Which court or tribunal has jurisdiction? And how will the eventual award actually be enforced? There is another advanced point to this. Subject to statutory requirements and agreement to the contrary, Section 9 can also have relevance in certain foreign-seated international commercial arbitration where the resulting award is enforceable and recognized under Part 2 of the Arbitration Act. That makes Indian interim relief strategy potentially relevant even when the arbitral seat itself is outside India. This is why enforcement architecture should be discussed when the contract is drafted, not for the first time after the default. So, if your company is facing a substantial commercial dispute, put these 5 questions on the boardroom table before litigation begins. 1. What exactly is our cause of action and strongest legal claim? 2. What assets could ultimately satisfy the claim? 3. Is there credible evidence that those assets are at risk? 4. Which protected remedy and which forum are legally appropriate at this stage? And 5. If we win 3 years from now, how exactly we turn that order into money? Because a favorable judgment is a legal victory. A successful enforcement judgment is a commercial victory, and as sophisticated businesses understand the difference. I am Advocate Ashish Rishi. On this channel, we decode Indian commercial litigation, arbitration, enforcement, and cross-border dispute strategy for businesses and legal professionals. If these are the issues you deal with, this is a series you should follow. I'll see you in the next one. Thank you so much for your valuable time. And if you have any queries, you want to get any legal notice to be drafted or agreement to be drafted, feel free to email us at legal@nwlc.in. Thank you very much. Have a blessed life ahead.